On Tuesday, the Supreme Court raised serious questions about an intervention by the state of Uttar Pradesh in a private legal dispute with regarding Sri Banki Bihari Temple in Vrindavan. The bench was comprised of Justice B.V. Nagaratna and Justice Satish Chandra. Uh, Both of them questioned that how a state could intervene in a private party's litigation. So the background of this case is that the Supreme Court on May 15 allowed Uttar Pradesh government to utilize public funds for the purpose of developing a corridor of the temple. So initially the dispute was a civil dispute, that is between two private parties, but later the state intervened into the case. One of the devotee named Devendranath Goswami now filed a miscellaneous application asking that earlier judgment did not to be recalled, like he was not heard while Supreme Court making this decision. Therefore, Devendranath Goswami has filed a miscellaneous application now before the court, and he argued that he was not heard, and such decision impacts devotees' offerings around 300 crores as well. And senior advocate Kapil Sibal, appearing for the devotee, he strongly opposed. Of course, he should have done that. He opposed the state's interference. He explained that his money in question are devotees' offerings to the temple, and he argued that state cannot take over temple funds through a case where those affected were not even the parties, right? And key questions were raised by two of the judges, that is Justice Nagaratna asked in what capacity did the state enter into the private dispute, and she also warned that if states begin to interfere in private cases and lead to breakdown of rule of law. She spoke about this, and Justice Sharma pointed out that modifying or recalling judgment without proper review is not legally permissible. That was his stance, Justice Sharma's stance. And the concerns raised are in November 2023, Allahabad High Court allowed the corridor project, but it restrained the state from using the temple's funds, that is 262.50 crores around. So the state was restrained from using temple's fund, but Supreme Court later modified this order and allowed the state to use the funds. But a caveat that the acquired land must be registered in the deity's name. And later, UP government defended itself, saying a new ordinance, the ordinance dated 26th May 2025, has been issued for better management and of the temple. So by this ordinance, it created a trust. Okay, so that trust would control the property and the funds. But however, this ordinance was not yet implemented as the state assembly is not in session. Mr. Sibel's argument, a senior counsel argument, is that the ordinance uh, is being used to indirectly take over the control of the temple, and he insisted that the trustee, Mr. Sibel's client, was was not heard, and that was his argument. Senior advocate's argument that the trustee, his client, was not heard. Without even hearing him, the court allowed the state to use the private temple funds, and this is not permissible, he said. The Supreme Court issued following directions that the latest ordinance must be placed on record through an affidavit by the principal secretary, and the next hearing will be scheduled on 29th July 2025. But in this hearing, Supreme Court did not issue any formal notice at this stage.